Hello, everyone. Welcome to the webinar today. We are thrilled to have you. We have a fantastic crew of panelist speakers today from Financial Tax Strategies, and we're going to be talking about how to defer capital gains with no 1031 exchange. I know 1031 is probably a lot of what you all have heard about for years and years, but there are other options, and we have a fantastic team that's going to talk to you about some of those. We have with us Ruth Benjamin and Scott Varney and Barry Bruce, a new member of their team. All of them have extensive experience working with real estate investors on not just 1031 exchanges, but other options as well, like monetized sales installments and looking at Delaware statutory trust and a couple of others that you may not know about just yet. Barry himself has over 40 years of experience. Even though he's new to the financial tax strategy team and you haven't seen him before, he has a ton of experience to back up what he's going to be sharing today, and he'll be in the Q&A as well to answer some questions. With that said, Q&A is going to be at the end of the presentation. Put your questions into the Q&A box, not the chat preferably, so that I can keep, and Barry can keep better track of the questions that come in. And then tomorrow, you all are going to get the recording, okay? So don't worry if you don't necessarily get to, every single little piece of information. It's going to be a lot, okay? We have some great content for you. So with that being said, I'm going to hand it over to Ruth so that she can get started and take away the presentation. Ruth, thank you so much for being here.
Thank you, Alexandra. Thank you for having us here today. And thank you, everybody, for being here today. So I am going to start out with a video to introduce Scott and I, and then we'll get into the presentation. So welcome, everybody. We have already introduced you to Barry, but while this is general information about monetized installment sales and other capital gains tax strategies, it does not constitute legal or tax advice. The best way to get guidance on your specific transaction is to talk to an attorney. If you don't have somebody that you can rely on, please reach out to us. We have a few of them that we like to refer out for all of our strategies, and they do write opinion letters for our strategies, so that way you can move forward with confidence. So we're going to introduce to you how owners of businesses, real estate, and other capital assets can sell your asset, defer the taxes for decades, and receive near the close of escrow a tax-free amount nearly equivalent to the sales proceeds. So I'm going to talk about monetized installment sales. It's based on IRS Code Section 453 and 453A. It's been around since 1913, way before 1031, right? But that section, the installment sale reporting section of the code, declares the general principle that when a taxpayer sells a capital asset and does not receive full payment of the selling price in the year of the sale, the transaction is an installment sale for which the seller owes the tax pro rata as and when the principal is received. Now, in 1980, Congress said a seller could receive loan proceeds in connection with an installment sale contract and still receive tax deferral. Now, we do have a memorandum out there that likes the monetized installment sale. That memorandum said that the monetized installment sale is good for the client and good for the economy. We also had a client that was in bankruptcy court. She could not pay all her debts in bankruptcy and pay the taxes. So the bankruptcy courts reviewed the monetized installment sale, gave their blessing, and let this client move forward so she could pay the tax bill 30 years from the time she sold her property. We also had the SEC. They reviewed the international paper transaction, and they have reviewed it and given their blessing on the monetized installment sale. So a lot of people will say, well, how come I haven't heard this before? Well, I'm an accommodator. I've been an accommodator for 30 years. When I started doing exchanges back in the 80s, they told us, I would talk to people about 1031 and people would say, are you sure? How come I haven't heard of it before? So I feel like this is deja vu all over again. I've been doing monetized installment sales for over 5 years now. I do them every day, working with clients, assisting other people to help their clients. So this is something that's more and more people are getting, hearing the word on it. But the reason that you didn't hear about it before is because the size of transactions that were done in the past. International Paper did one in 2010. Office Max did one in 2008. Kimberly Clark did theirs in 2002 for $617 million. So because of these large transactions is a lot of reasons people don't hear about it. But we now have two capital asset dealers. Those are the form of intermediaries. They're called capital asset dealers. And we have two of them in the market, and they allow anybody to use the monetized installment sale with the sales price of 500,000 or higher. If you don't have a property that's 500,000 or higher, reach out to me. I am able to do them for lower. I can make exceptions to the rule with one of the capital asset dealers. So don't let that be deterrent. Reach out to us no matter what the size of property that you have. So let's take a look. If you sold a property for $1.8 million, you bought it for $450,000, you put $200,000 worth of improvements. Remember, you're always going to have depreciation recapture tax. Now, some people will tell me, but I didn't depreciate the property. Well, unfortunately, the IRS is still going to hit you with the depreciation recapture tax. So what's subject to capital gains is over $1.2 million. Now we know the federal rate right now is 20%. We know it's going higher. Now the state of California is 13.3%. And I know we're the highest state tax. And then there's net investment income tax. People know it better as Obamacare. That's an additional 3.8%. So if you sell this property without doing any type of tax deferral strategy, you're going to write a check to the IRS for over $514,000. Now, I personally would cry if I had to write that type of check. So we're trying to help you, instead of writing that check to the IRS, keep that $500,000 in your portfolio, make it grow over the next 30 years, and you can turn it into $3 million or more. If you don't have a person that you currently work with, a financial advisor, reach out to Scott. He will be able to show you how to grow that money into $3 million. So when 30 years comes up and you have to pay $514,000, you'll have $3 million to pay that bill. Now, often sellers can face as much as 30 to 40% or more of your profit going to taxes. The cost of the monetized installment sale is 6.7% of your net sales proceeds before any mortgages are paid off. And then there's a $300 annual fee. So every January, you're going to get an invoice for $300. Takes care of the whole year of processing fees. And Scott's going to cover that in just a few minutes. So now there's a way to sell your asset. Postpone constructive receipt. Constructive receipt is where you touch the money and the IRS will tax you. So we're going to postpone that. We're going to postpone the tax bill, and you're going to receive nearly equal to the selling price, your cash today. This is not, you're going to get monthly payments. You're going to get it all right now. And we're going to show you how to do that. So consider using the monetized installment sales if you want to defer taxes on capital gains, if you want to defer taxes on cancellation of debt. We know the market's going to be changing. There's going to be a lot of people losing their homes, and they're going to have a debt problem, cancellation of debt. We can defer the tax on that. Debt over basis. a lot of people don't even think about, if you bought a property and you had a certain loan amount on that property, let's say, make it small, $200,000 loan when you bought the property. And then when you go to sell your property, let's say your loan is now at $1 million because of the growth of the property. Well, the IRS is going to tax you on the difference of the 200,000 to the million. They could tax you up to 39.6%. So take a look at that. If you didn't use that money to improve that property, you used it on something else, you could be taxed. So be careful with that one. You can defer depreciation recapture tax. If you have an exchange that's failing, we can move it to the monetized installment sale if you use the right accommodator. I am one of those accommodators that has a provision in my exchange agreement that will allow you to move to the monetized installment sale if by chance you can't find that replacement property that you want. It kind of removes some of the stress that comes with 1031 exchanges. Or if you already have carried back a note for a buyer and they're going to pay you off, you can put that note into the monetized installment sale and defer the taxes for 30 years. Now, you cannot use this strategy for listed securities through a public exchange, but we have other strategies that will work for this, okay? So who can use this tax planning approach? Besides us as individuals, business entities, corporations, LLCs, and partnerships. We have professional practice, a dental office and a law firm use this strategy. You can use it for real estate, whether held for business or investment purposes, primary residence, fractional interests, mineral rights, cryptocurrency, contract rights, franchise agreements, license agreements, and long-term leases. I touch on long-term leases because if you don't own the land, you lease the land, look at that lease before you sell, because if you want it to be considered real property, you have to have 30 years or more remaining on that lease before you sell. It also works for art or antique collections, aircraft, watercraft, and classic automobiles. And I am going to turn this over to Scott, and he is going to walk you through the process on how the monetized installment sale works.
All right, I've got to get rid of the better looking me and share my screen. There we go. Okay, so let's get into the mechanics of this a little bit more closely. So typically you have in a transaction, you have a seller, you have a title company, and you have a buyer. When you do this type of monetized installment sale strategy, you add more parties to the transaction. You're going to see there a capital asset dealer. You're going to have a lender, third-party lender that is separate from the dealer, and you're going to have a 1031 intermediary, or what some people call exchange accommodator. So what's going to happen is after the seller negotiates a contract and it's been executed with the buyer, then the seller turns to the asset dealer and does an installment sale agreement for the net sales proceeds. Now, the definition of net sales proceeds is a little bit different here. In your typical transaction, as real estate professionals, we know that that's the bottom line figure that the seller gets on the HUD-1 statement. But in this type of transaction, it's the contract price minus the closing fees. That's minus the real estate commissions and the title closing fees. So once you subtract those, that's the net sales proceeds. Even if there is debt, it's before you pay off debt. So you do an installment sale. The terms are, it's a 30-year term. So we're going to use this to defer the taxes for 30 years. It's interest only. There's no principal being paid because you pay taxes when you receive principal. Here, you're not receiving any principal. And then it's 100% of the net sales proceeds. So essentially what's going to happen is the seller is going to sell the asset to the asset dealer, who in turn sells it to the buyer. However, the seller is going to direct deed the property to the buyer. The asset dealer does not ever take title to the property. So now the buyer, the seller, they've done everything, the inspections, got the loan approval if the buyer is getting a lender, and now they go to the title company to close and sign all the documents. They will bring their money, and if there's a lender, that after the lender has approved of all the docs, they will fund the loan. So all the money ends up at the title company. Once it's there, everything's closed and funded, and buyer's now able to get the keys. The funds go from the title company to the 1031 intermediary or to an attorney trust fund. So once that happens and those funds are moved to the intermediary, the title company and the buyer are no longer part of the transaction. The buyer has their home, their new home, with free and clear title. Everything's done. They move on. All right. So once the funds reach the 1031 intermediary, there is an amendment to the exchange agreement that is signed between the intermediary and the capital asset dealer. By doing this, the intermediary will eventually release the funds to the asset dealer. But you have to make sure that the accommodator or intermediary is willing to cooperate. Some of them do not. IPX is a great 1031 exchange accommodator, but they do not release funds to those who work with tax code 453. So you'd be stuck if you picked IPX as your intermediary. So now, once that agreement is done, then the funds are released to an escrow company, attorney trust fund, and not to the asset dealer. The asset dealer does not touch the money yet. There are escrows that are open. We call them funding escrows, one for the asset dealer, one for the seller, and one for the lender. And this is going to cost the seller $300 per year. Now, these need to stay open. So in some cases, our clients ask to pay the 30 years worth of annual fees up front because they get enough cash at closing. So the $9,000, that way they're not getting that annual bill because that's pretty critical to the strategy. All right, so after this is done, the lender provides a loan, what we call the monetization loan, to the seller. That loan is going to be for 95% of the net sales proceeds minus closing costs. Sorry if you hear some noise. My poor dog is running outside. All right. So the closing costs, 1% loan origination fee, and then 0.5 to 0.7% escrow fees. So you get 95% minus the 1.7%. So essentially, the seller is going to receive a wire of 93.38% of the net sales proceeds within 5 days after the close of escrow. So they're going to get all the money they're ever going to get within those 5 days into their account. And they're in absolute control of those funds. So after the seller gets the funds, the escrow company is going to actually confirm that the seller has received the funds. After it has been confirmed, then they will release the net sales proceeds to the asset dealer. This is a great protection for the seller. The dealer is not going to get the money and run to Mexico, so there's no worry about that. So basically, the dealer gets the money after you get all the funds you're ever going to receive. So what's going to happen? So now you have your money, all the money you're ever going to get from the transaction to go invest. The asset dealer now invests the net sales proceeds, and they're going to try to earn 7, 8, 10, 11% per year, and they owe the seller 5.7%. So they're going to make the difference on that, the spread on that. So if they make 8% and they pay you 5.7, they're making 2.3% per year on that money. That doesn't sound like a lot, but when you have millions of dollars going into this, that turns out to be a lot of money. So now every year, let's say the asset dealer got $1 million. They're going to be paying $57,000 of interest every year to the seller's escrow account. Now, understand this. Again, you received all the money you're going to get within 5 days of close of escrow. This is ghost money. You never touch this money, but you do get a report every year called a 1099 INT, which is interest income that you have to report. Even though you don't touch the money, that's reportable income. Now, you have a loan for it's a 95% loan, and it's for 6% annual interest. Well, notice here, that comes out to be $57,000. So essentially, The dealer is going to pay the interest to you, and then you're going to pay the interest to the lender. So really, who's paying the interest on this loan? It's the capital asset dealer. Because the contract between you and the lender states that it is looking to the installment sale agreement to fund the loan. You're not paying that. Now you have interest income, $57,000, but now you get to write off $57,000 as an expense, a legitimate expense. So it washes out, so you do not have to pay any income taxes on that on an annual basis. Why is that? Well, because it is what's called an investment business loan. So when you receive those funds, they're to be used for business. You could buy other real estate. You could pay off loans on other real estate investment properties that you have. You can start a landscaping business. If you're in real estate yourself as a realtor, then you can use it for marketing, whatever business expense or any kind of investment vehicle. So savings accounts, CDs, mutual funds, stocks, cryptocurrency. As I talked to somebody yesterday, they want to sell a 97 unit apartment building and even get into the blockchain space. So that's an investment that they're going to do. All right, so this goes on for 30 years. There's reportable income and reportable expense. At the end of 30 years, the contract between the seller and the dealer states that if the dealer makes the payments on time every month for 30 years, when they make the balloon payment, they get a 5% discount. So instead of paying $1 million into the escrow account, they're going to pay $950,000 as the balloon payment. That balloon payment goes to the seller. Now that contract has been completed. The seller's account pays the $950,000 to the lender, which is the loan amount. That contract is now completed. Now the seller has constructive receipt and the taxes become due, unless you do the strategy again and kick the bucket down the road another 30 years, which we've been advised can be done. All right, primary residence. Many people call us looking to try to address the capital gains taxes on their primary residence. In small number of cases, can we make it work with this strategy? Special care is needed. That requires a one-on-one appointment. This is great with the investment properties. Primary residences, it's not so great because of their goals. But talk to us. Maybe your case is one that it does work. All right, so what happens if the dealer doesn't make the payments? Well, there's no default risk whatsoever for the seller. The loan is unsecured. The seller's assets are not attached in any way. The loan agreement between the seller and the lender provides that if the dealer does not make the payments for any reason, the seller is not obligated to make up for the dealer's default. Basically, I'll go back here. The first thing that they're going to do is look to those escrow accounts. You got to make sure you keep those open. The lender cannot issue a 1099-C, which is a cancellation of debt, which is reportable taxable income. They cannot go after any of your other assets, and they cannot report anything negative on your credit report. When you get that loan, you've never applied for it. It's built on the credit worthiness of the asset dealer and the fact that the lender trusts how they are going to invest that property or invest those proceeds. So Ruth mentioned nearly equal to selling price. What does that mean? Well, $1.8 million sale after closing costs, you're at $1.692 million. Then the 95% loan, then all the closing costs gets you to $1.58 million is what you're going to receive on a $1.8 million sale. Now, if you were to have to pay the taxes, so get rid of the monetized installment sale, you have the $1.692 million, and then you pay the taxes the next year. In California, you're looking at $1.177 million. So which would you rather have to leverage? It just depends. It depends on your goals. But if it's an investment property and your goals fit, this is a great way to leverage the extra income for your estate. So how does the lender make money on the deal? They get a 1% loan origination fee and they make 6% annual interest every year. They're happy with that. What happens if the seller dies before the 30 years is up? There are two answers to that. The first one is if you have passed away, I guarantee you are no longer worried about the tax bill. All right, so I always have to put in a little fun. But the second answer is it does not trigger the taxes due. So if you pass away 15 years into it, the contract still continues on for 30 years. So it's still not for another 15 years that the taxes become due. So we encourage people to talk to their estate planning attorney, their living trust attorney, to let them know that this tax bill is coming due in 30 years and be prepared for it. So when does the tax get paid? In 30 years. Now, how much tax is going to be paid? We don't have a clue. If you have 500,000 of gain today, you have 500,000 of gains 30 years to report. 30 years from now. But what's the tax rate going to be? Is it going to be higher, lower, the same? That we don't know. Right now, they're already talking about raising the capital gains tax, which I'm going to talk about in a minute. So, but the gains is still going to be the same, but the rates have gone up 4 times and down 3 in the last 30 years, about to go up again. So we just don't know. But even if the rate is 100%, if you invested at 5% growth and the tax rate's 100% of the gains, you still have way more money for the estate and the tax bill. So you're okay. So what's the value of the monetized installment sale? Many of us call it MISS for short. Monetize installment sales a lot, just the MISS strategy. First of all, it's flexibility. You do not have to replace your property with a like-kind property of equal or greater value, like a 1031 exchange. You can put the money into any kind of business. You can pay off debt on other investment properties you have. It's a great opportunity. You can, again, put it into your real estate business or your landscaping business, whatever you have. That works, or any kind of financial vehicle. So it gives you a lot of flexibility. For many of our prospective clients that we talk to, it's a great exit strategy. They don't have to deal with the tenants, the trash, the toilets, all those T words. So anymore, they can call up their financial advisor and say, I sold my property, please invest my funds. Guide me in that. And they can enjoy retirement. And as that money's growing, they're collecting that growth and not having to deal with those troubles anymore. No 45 or 180-day requirements that you have with a 1031 exchange. That's problematic. At least 40% of the exchanges are going to fail. Sometimes it's up to 60% of them will fail. And so here you can sell while the market's hot, and you can sit on your funds, do short-term investments while waiting to find the right fit. You don't have to find the property within 45 days. You could sell while it's high, wait for the market to crash somewhere, and kind of go in and buy some foreclosures. You have flexibility. Also, if you do pursue a 1031 exchange and you don't find the right fit, remember, you don't have to buy a property if you have a backup plan. So if nothing works out well, then you rescue a failing exchange with a monetized installment sale, still defer for 30 years, and you're good to go. And no replacement loan is required. So if you have debt, so let's say you're selling $1 million property and you owe $300,000 and you do an exchange, you have to buy $1 million property and you have to replace the loan with a $300,000 loan unless you pay cash to replace it. So you have to replace the loan. Here, you could do the monetized installment sale. The loan is paid off, and whatever cash you get, that you can invest without replacing the loan, because the monetized installment sale loan is the replacement loan. So you have a lot of flexibility there too. Increased depreciation. I'm a numbers guy. I love looking at this. So let's say you bought a property for $250,000. You've owned it for 15 years. It's now worth $1.2 million, like in the San Francisco Bay Area kind of appreciation. Now you're still in asset accumulation. So you sell for 1.2 million, you buy a new property for 1.8 million. Moving forward with this example, you have $499,000 of depreciation available over the next 27.5 years. if it's a 1 to 4 family unit property. With the monetized strategy, if you sell and do a monetized installment sale, moving forward, you have 1.259 million in depreciation. There's an extra 760,000 in depreciation available because you use the monetized installment sale as opposed to a 1031 exchange with this example. Significant difference. All right, numbers, goals, and personality. When you reach out to us, we're going to look at the numbers. The cost again is 6.7% of the net sales proceeds. Does that number fit with your tax bill? In some cases, if the tax bill is 100,000 and the cost to do the strategy is 84,000, that doesn't make sense. But if it's $120,000 cost and the tax bill is 400,000 and you have 280,000, so over 30 years that becomes $2.1 million at 7% return. That makes sense. So we look at the numbers to make sure it works. The goals, if you're looking at selling a property and going and buying a mansion, primary residence, that's not a good fit. And why? Because I'll go back here. Whoa. You see here, 57 income, 57 expense. If you use half of your funds to go put it into a primary residence, you only get to write off half of this. That's 28.5. So every year you would have taxable income to report of $28,500. Now the annual income tax might negate the value of the tax deferral, but we have to look at those numbers to make sure it's a good fit. All right. And then personality. Sometimes the numbers fit, but the person's like, I don't want to deal with tax reporting every year. I just want, as one guy said, I'm lazy. I just want to buy my house in Flagstaff and I just want to go fishing. Hey, that's perfect. Pay the tax. You're blessed, with all the appreciation, and go fishing. Enjoy the rest of your life. All right. Easy as 1, 2, 3 strategy. Set up your exchange with an accommodator that will cooperate with monetized installment sale intermediaries, those who are going to use tax code 453. And once you've done that, you set yourself up for success. Go find your replacement properties. Even consider a Delaware statutory trust property as a third replacement property or as a backup plan. And then if nothing good and acceptable comes together, then you identify a property within the 45 days, and then you can move it to the monetized installment sale anytime within that 180 days and get the tax deferral. So set yourself up for a success, but the key is hiring the right 1031 accommodator to begin with. Again, there are great companies out there like IPX that are great exchange companies, but they will not allow you to rescue a failing exchange with any of the tax code 453 options. All right, step-by-step process. Talk to your tax attorney, your tax professional about this strategy. Have them talk to us. List your property with your agent. When it goes under contract, reach out to us and Ruth will get you a letter of intent from the dealer. Once you've signed the letter of intent, it allows us to release the documents to you for your review. And it allows you to have your advisors review it, not your brother, your sister, your neighbor, your uncle, but your advisors like your tax attorney, your CPA, to look at the documents to make sure everything is in order and acceptable. Then you communicate with your title company that it is a 1031 exchange. If it's not going to be done as an exchange, it's going to go straight monetized installment sale. Ruth will guide you as to what you get to the title company. You're not communicating, you're doing the monetized installment sale, because then they start every closer out there is going to start getting the attorneys involved in everything, and it's going to delay things. It's not that it's an issue as much as it could cause your buyer to get really mad because the closing's been delayed. So we have ways to do this to make it happen more smoothly. So once all the documents are signed and transaction is closed, you'll receive all the funds you're ever going to receive within 5 days of close of escrow. And then you reach out to your tax professional because they're going to do the tax reporting the next year. All right, the second strategy, we're going to talk about how to defer capital gains taxes for generations. Now, federal taxes, yes, state to state to state, it varies. So we're not promising you'll be able to defer in your state, the state capital gains taxes. So there are problems. So I'm going to give you the bad news. I'm like Eeyore, we have problems. So part of the problems that this trust will solve is the capital gains taxes. So again, federal. Now, federal taxes are being proposed to go up from 20 to 28%. On anything over $1 million, 39.6%. And that is your income plus the gains gets you over $1 million. That's going to be a problem. 1031 exchange stressors, because so many of them fail. That's a problem. And right now they're looking at, they were talking about eliminating 1031 exchanges. That's not likely to happen, but who knows? It might. Right now they're proposing that they cap the exchange at 500,000. What do you do with the rest of that? Well, the monetized installment sale can do the balance if there's enough of a left in it to make the strategy worth it. So 1031 exchange stressors, the trust can address. Income taxes that reduce the return on investment. So many of our clients make a lot of money, W-2 income. That's how they can afford their properties. And when they pay taxes after the depreciation, when they have income to report, it's at a higher rate because they already made a lot with their W-2 income. So that hurts their return on investment. Future laws, again, there's a lot of proposals going on, getting rid of stepped up in basis, capping the 1031 exchange. There are so many things going on. You have to watch what's going on. And right now, the proposals will put 13 states over 50% of the gains being taxed between the federal, the Obamacare, and the state tax. So watch the future laws. Lawsuits. You know, do you have solid asset protection? Most people do not. And so you have to make sure that you're set up that you don't lose. The number one rule, I even do a stair step of how to build wealth and financial independence. Rule number one, do not lose what you have. And that's lawsuits is one way that you can lose everything you've built. Problem number 6, corporations. They don't protect you as well as you think. It's easy to pierce the corporate veil because they're tightly held entities. Basically, you're operating as your alter ego, and the courts claim that you are controlling the owner of the entity. It's a very winnable argument with a judge. And many people don't even keep up with the proper records, meetings, and minutes that they're supposed to legally have. And that's one way to pierce the corporate veil. 50% of them can be pierced just because you don't have those in order. Once this trust is set up, you don't have to deal with those meetings and minutes and records. Now, what are we talking about? Wake Forest University did a research, and they found that between the state and federal courts, 40% of the time, on average, those corporations were pierced. So if in a lawsuit, the person who is suing that LLC, 40% of the time, they had access to those assets in the award. 4 times out of 10. That's not as strong as you think. Problem number 7, insurance is only a partial solution. It's a great solution to some point, but here's homework. Call your insurance agent if you have an umbrella policy. If you don't have one, get one. But call them, ask them if they cover punitive damages. Many of those policies do not cover punitive damages. What is that? That is gross negligence. If you are at fault in a car accident because you ran the red light, that's gross negligence. And if it's a $2 million award and 1.5 or 1.6 million of that is punitive damages and your insurance did not cover that, that's out of your pocket. So make sure that you are insured properly. Problem number 8, filial responsibility statutes. This is scary, especially with the cost of long-term care right now, $25,000, $30,000 a month when you get into the more intensive care part of it. So 30 states have this statute. It allows long-term care facilities to seize the assets of adult children to cover unpaid bills of their parents. If mom is in a facility and the bill's racking up 2-3 months later and they haven't been paid, and there's a $90,000 bill, they turn to the adult children and say, pay up. And if children go, we don't have that cash, they go through a process, they can seize assets from the adult children to pay that bill. That's scary. All right, so Tigger, Ruth Benjamin, she's the fun one, is going to provide the good news and the solution. Go ahead, Ruth.
All right, let's get the solution to all of these problems that we have. And we're going to break it down a little bit. What Scott was alluding to. It is, break it down. What is it? It's a dynasty spendthrift trust. It is, as you know, there's many trusts out there. A lot of people are talking about trusts. There's hundreds and thousands of trusts, but this one dynasty spendthrift trust has all of these components. It is a non-grantor, irrevocable, complex, discretionary spendthrift trust. It's a dynasty trust that is not self-settled. This trust is a contract between the grantor, the trustee, and the beneficiaries. The primary purpose of this trust is both tax reduction and asset protection. So the non-grantor portion of this trust provides the ironclad asset protection. The irrevocable portion of this trust also provides for the asset protection. The discretionary part is what helps defer the capital gains taxes, and the provisions address income tax issues. So it helps mitigate income taxes paid by the self-employed. This trust doesn't help W-2 employees unless you have a side business. The complex trust portion is what also helps defer the capital gains taxes, and the provisions address income tax issues and helps mitigate the income tax bill for the self-employed. The spendthrift provision is both. It provides the ironclad asset protection and the tax benefits. So as these definitions suggest, this unique type of trust is designed to protect your assets, to defer, reduce, and lessen your tax bill. It also eliminates liability and provides for your beneficiaries without legally affecting the corpus of the trust. The corpus of the spendthrift trust is not subject to turnover orders by any court or judge, whether federal, state, or local. So the corpus of the trust is the trust checking account because it's under its own EIN number. So we have a couple case rulings that support the spendthrift provision. In Edison versus McLogan, they ruled that persons may adopt any lawful means for lessening the burden of income taxes. In Weeks versus Sibley, the courts ruled that a spendthrift trust organization is not illegal, even if formed for the express purpose of reducing or deferring taxes. So let's break this down in simple terms. Our Dynasty Spendthrift Trust defers taxes for generations. Federal taxes, absolutely. State taxes depends on your state. We do know in the state of California, they are very aggressive. So Californians, I'm sorry, you're going to end up paying California tax, but talk to Barry. There are some things that Barry can suggest for you. So a trust has to have an ending date to be valid. The trust will end 21 years after the death of the last heir from when the trust was created, with an option to renew every 21 years. So 10, 20, 30 generations, hundreds of years later, that's when your trust will end. Now, this trust will be taxed either when the trustee decides not to renew it or 21 years after the last heir to the last beneficiary has passed away. Last year when I set up my trust, my grandson was 1 year old. So if I don't renew my trust in 21 years, my trust will end 21 years after my grandson's children, his grandchildren, and great-grandchildren all pass away. 21 years after that date is when my trust will end. So the roots of our trust come from the Dynasty Trust. The Rockefellers and the Kennedys have this type of protection. So now you set up your trust. You decide what assets you want to put in your trust. Put what you want, and ones you don't want, you don't have to. But I always feel if I got sued today, what would I not want to lose? You want to put that into your trust. So no federal capital gains taxes at the time of sale. So you want to put your real estate, your business, stocks and bond market trading, your Bitcoin, cryptocurrencies. You can sell assets to another trust, no federal or state probate, and no gift tax. Zero federal capital gains on the growth or sale of trust-owned assets. The sale of of your assets are non-taxable events because you're selling your properties to your trust at basis. So unlimited amounts of assets can be sold. So if you're a person that has an LLC for every property that you own, that's absolutely the way that we were told to do it. Well, now with this trust, you only need one. All your properties can go into one trust. You can get rid of the LLC fees. You can get rid of all of the tax returns for all those LLCs using this trust. So the trust may provide for a solid alternative for 1031 exchanges because now the trust sells your asset. The sales proceeds go to the trust. There are no restrictions as to how and when those funds are to be used. You can choose to invest outside of real estate if you choose to, but if you do decide to buy real estate, you buy that real estate when it's the right fit. We all know the market's going to crash, right? So why would you want to sell high today, but why would you want to buy high today? You want to wait until the market shifts and now you can buy that property. So the trust helps with passive income. That tax bill, passive income. So that's your rental, lease income from your property or business, stocks, future sales of your properties now paid to your trust. Zero capital gains taxes due when the property or the business is sold, and 78 to 97% or higher, your income tax reduces, okay? And it's deferred in perpetuity. If you have active business, so the trust can't help anybody that is a W-2 employee unless you have that side business. But if you have an active business, something that you are working in, putting in the hours, you can reduce your income tax bill 78 to 85%. So last year, if you have a tax bill of $50,000 and you set up your trust this year, then that if you made the same amount of money, your $50,000 last year check will now be reduced to $7,500 to $11,000. So how would you like to defer taxes on any income derived from intellectual property, which includes books, membership sites, coaching and mastermind programs, home study courses, and coaching? So you as a trustee can tie the trust to a separate business trust or intellectual property trust in order to significantly reduce income and payroll taxes otherwise payable by operating businesses you own or in whole or in partnership with others. So the trust can also utilize tax deferral strategies in order to strengthen tax mitigation if needed. So you can still use within the trust. If you're in California, you might want to use some of these because you don't want to pay that California tax. It's just high, right? So you can still use the 1031 exchange within the trust, the monetized within the trust, Delaware statutory trust opportunity zones, angel or other venture capital investments in section 1202, small business stock, and other tax planning tools that provide long-term, even permanent deferral or elimination of capital gains taxes. So now you have the sales of your properties in your trust checking account. How do you spend that money? So the trust checking account can pay for all of these expenses, your home expenses, your mortgage payment, your pool guy, your cleaning lady, your cable bills, okay? That can be paid out of this trust checking account. Your vehicle, so your car payment, your gas and maintenance for your car, medical, contributions, tuition, room and board at college for your beneficiaries or yourself, wellness, interest on credit cards, telephone, life insurance premiums, bank and credit card charges, and postage. So all of these expenses are no longer after taxed, that you've been taxed expenses. So the only thing that you cannot use that trust checking account money for, we call it the 3 F's: no personal food, no personal fashion, no personal fun. But if you have any children under 21, or you have somebody that's disabled, your trust can pay for their food and fashion. So you initially sell all of your assets that you choose to your trust. In doing so, you create a demand note. So now the trust owes you. So each year you can have the trust pay you a portion of the funds owed to you by the trust. So there will be a small interest rate that the trust owes you. So a small portion will be taxable. So Nelson Rockefeller says it the best: the secret to success is to own nothing but control everything. So the trust timing, contact Scott and Barry for a consultation for the trust. If you're ready to move forward, the docs will be drawn by the trust team and an EIN number will be established for your trust. Now, if you want to use the trust and you're thinking of selling, you need to get the properties into the trust right away. It's best used if you're not putting the properties in the trust in the same year that you're selling. But with that being said, we have people all the time that put it in the trust and sell right away. It depends on your comfort level. Okay, so if you're currently under contract on a property, you need to cancel that contract, put the contract in your trust name. You cannot do this by an addendum. So please talk to Scott and Barry on the best way to handle that. Get all your assets in now, so for the future, you're ready to go. So the pricing of the trust for the personal trust. So this is it handles everything except for active income, $39,000. Okay, so it gives you the asset protections, defers the tax bill, all right, lowers the passive income tax bill. But now if you want to lower your business, your active income tax, you need to have two trusts. You need to have the personal and the business. So the cost of the two combined is $73,000. Our trust, we have attorneys that will write opinion letters. The cost of the opinion letters are about $5,000 plus. And the reason is these opinion letters, I look at them as your insurance policy against the IRS, right? So we do have people we can refer you to get opinion letters to make sure this is a great fit for you. But these costs includes the first year's prepared tax return and 1 year consultation. There's no annual fees. This is it, one-time cost. The only additional cost you might have is if you have a lot of properties to deed in, they may charge you for those additional conveyances. Typically, it's between 5 and 10 is what they will put in before they start charging you. So let's recap this wonderful trust and its benefits. It eliminates federal capital gains taxes in most states but California, right? Yes, it does. Does it defer income on passive income in perpetuity? Yes. Does it avoid lawsuits? Yes. Does it avoid judgments and liens that can reach your business assets and reach your personal assets? Yes. Does it avoid probate upon death? Absolutely. Does it avoid gift tax and estate tax? Yes. Does it ensure the transfer of your assets get to your beneficiaries? Yes. It's multi-generational wealth accumulation. It avoids annual fees. Yes. So this defers federal capital gains taxes without doing a 1031 exchange. And in some sophisticated living trust, you already may have some limited asset protection, but I know it is not as good as what this trust provides. Even if your estate is worth over 11.58 million, no gift or estate taxes will be owed by your heirs. And we want to thank you for attending. We're going to ask you to go to our YouTube channel and subscribe. We are creating several videos on a lot of our tax strategies, even some that we don't even talk about and do webinars on. But if you subscribe to the YouTube channel, you will get $100 off your next exchange that you choose to do. And we also do group presentations. If you have friends or anybody that wants to hear about that, reach out to Scott. So at this point, I am going to end the presentation so we can answer any questions that we haven't already answered in the chat box.
I just posted on the chat box the direct link to the YouTube channel. And again, if you have questions, as Alexandra has been pointing out, put them into the Q&A so we can follow that. Barry's been doing a lot of answers, but there is one thing that did come up that I do want to address, the Franchise Tax Board ruling. So a lot of people, when they saw that ruling, they believed it said that the FTB was ruling against monetized installment sales. The answer is no, they did not rule against monetized installment sales. They ruled against monetized installment sales and deferred sales trust, tax code 453, rescuing a failed exchange past tense. They didn't rule against it rescuing a failing exchange, just a failed exchange. So if you watch it and read it carefully, you'll see the verbiage, and a lot of people miss that
Yeah.
part of it.
I want to add to that. The tax attorney that writes opinion letters is here in California with us. She spent several hours on the phone with the Franchise Tax Board, and she is writing opinion letters for these. So you can feel confident. We can attach, make introduction to her. You can talk to her about your situation, see if it's a good fit for you.
That's great. Before we move on, I did want to throw out a poll question because I know you mentioned several times that there are ways that people can reach out to you, but I'd like to make it a little easier for those of you who are on the call still that want to have Scott or Barry reach out to you. If you want to say yes to the poll question on the screen, we'll go ahead and connect you with them. And it breaks down the 3 different strategies that we talked about today. So you can sort of indicate which one. If it's more than one or you don't know, just select one. It doesn't matter. You're going to get contacted anyway. If you don't want to be contacted, it's okay. You don't have to answer the poll question. We'll only contact you if you do in fact want to be contacted. And by the way, Ruth, really great. And Scott too, on breaking down this really, I think it's pretty complicated sometimes, but you make it sound simple. So I really appreciate that. We did get some questions as well that I thought were interesting. Mainly, I want to kind of go back here to weighing the tax advantage versus the risk of not getting the payment on time or not being paid in full or ending up getting back the property or business that was out of your hands. Jerry, I'm not sure if I understand that question completely. We may have had somebody answer it already in the Q&A. Let's see. I think that was the only one I saw that you all didn't get to. Otherwise, it looks like Barry did a great job of replying to all the questions. Did you guys happen to see that one from Jerry in the Q&A?
I'll go back and look. Now somebody's asking us to show our phone number on the screen, so I'm going to share my screen real quick for just a minute or so you guys can get that.
Perfect. There it is. Perfect. And I'll email it to everyone tomorrow. You're all going to get the recording as well. So don't worry if you missed anything.
Get your camera out, take a picture. That's what I always do. I can't write fast enough, so I just get my camera.
And if you go to the very top of the chat, the very beginning, our contact information is there too.
Oh, that's true.
In the chat box. That's right.
Yes.
All right. So I'm going to stop sharing so we can get back to questions. Now
By the way, as always, Alexandra, thank you for hosting this with us. This is awesome.
Absolutely. Ruth, go ahead.
Well, the person who asked that question, reach out to us because you have several questions in it, and we'd be happy to walk you through each part of that question.
Fantastic. Rodney had a good one too. I know Barry answered it, but I think it's worth mentioning. Rodney said, I've heard mentioned that capital gains may not apply if the entity is a family-owned business managed by a family member. Is that correct?
So the answer to that is you can still defer taxes as a family business unless there is some reason that your attorney has that you can't do it, but we don't know of any reason why you would not be able to do it.
Another great question. I know you've covered it, but I want to clarify because we went over a few different methods here. The first question that we got in the Q&A was, my rental property has just been put on the market for sale. How much time should I give you to do your method to avoid tax on the capital gain?
I like 2 weeks. I can do it in 2 days and even in 2 hours if I had to. So just reach out to me as soon as possible. We want to give you the comfort level of not feeling like you're doing tax reaction, right? We like tax planning, not reaction, but we can do it really fast for you.
Okay, great. Another good question was, can it be for 10 years? So we're talking a lot about 30-year increments. And I know you answered that one, Ruth, for the
Yeah.
anonymous attendee.
So the monetized installment sale is always 30 years. You can end it in 10 years, but we really want you to look at it. The cost is 6.7% of the net proceeds. Is it worth paying that cost for just 10 years of tax deferral? We don't know any reason why. Well, the only reason that you'd want to end it early is if for some reason you took a loss somewhere and that loss would offset your gains. Then of course end it, okay? Because now you can offset the tax. But any other reason than that, usually you wouldn't want to end it. So talk to us and make sure that this strategy is a good fit for you.
Okay, great. Another question here on timing from Molly. She was asking, if my property is shared by my siblings and it's already in escrow, is it too late to be a monetary installment sales or miss?
It is not too late. Reach out to me. I can get that paperwork put in place so you can do the monetized installment sale.
Okay, great. And Scott, I know you touched a little bit on this Biden proposal. I know that they're proposing a lot, right? We don't know exactly what's going to really happen. I'd love to hear your take on it and how you've been sort of interpreting that.
Be afraid. Be very afraid. That's how everybody's interpreting. I'm getting on these calls. I'm on these hour-long calls going, oh no, I'm in trouble. These are all proposals. So that's the first thing is, it hasn't been approved yet, but the Biden administration has a clear path to get things approved because of everything with the Congress, that Senate, all that. Mm-hmm. So the House and the Senate. So the ones that are most concerning is 1031 exchange. Initially last year, he proposed to eliminate 1031 exchanges. This year now, it's being adjusted. Now let's cap that at 500,000. If that gets approved, then you're going to get taxed on everything over the 500,000 allowed, which the monetized installment sale can do the difference. So we have a way to rescue you. The one that is really concerning, especially for those who have accumulated a lot of assets over 10, 20, 30 years, is they look at eliminating step up in basis. What is that? You bought a property for 250, you sell it for $1 million, you have 750,000 in gain. But if you pass away and it's worth $1 million, your beneficiaries get a step up in basis. So when they sell it, it's worth, the basis is $1 million instead of 250. So they get to save that 750,000 in gains. They're looking at eliminating that. So everybody that's been accumulating a lot of wealth, knowing that they keep it till they pass away and the kids get step up in basis, they're going to try and eliminate that. That one's scary because there's going to be a lot of taxable income. And then he's looking at reducing the estate tax significantly. Right now, there's an 11.58 million per spouse exemption. So when you pass away, if you've got 23 million in real estate or assets, there's no estate tax. That's 40%. He's trying to reduce it to 3.5 million per person and up the tax to 45%. So those of you who have been accumulating a lot of wealth, that means you get a $7 million exemption and everything over that's taxed at 45% going to the kids. So there's a lot. Basically, he's going after the wealth of real estate to get the money he wants to pay for whatever. So watch the Tax Foundation is a good place to look. Taxfoundation.com, I think it is, to look at proposals. But they're proposals. 1031s have been proposed for decades of being eliminated. It just hasn't passed. So
Yeah, and I hear a lot about the pushback on that is really just the effect it would have on real estate investing and the entire real estate market as a whole, which, as we know on the call, is a huge part of what drives the economy. And yeah, I could definitely see the argument against it and why that might not pass. So let's go ahead and see if there's any other good questions here, unless you've seen
Yeah.
one that you'd
Well,
like to
I
address.
do want to, I want to address this too. You bring up a great point, Alexandra. And, if they put the cap at 500,000 with the 1031 exchange, a lot of real estate is within that 500,000 in the country. They're going after the ultra wealthy is what it is.
Mhm.
So
And just know that no matter what they do, we have other strategies for you.
Yes, and that's perfect timing for this webinar, honestly.
Mhm.
Did you see any other questions that you want to address? I can certainly pull up a couple more. I know we're over the hour mark, so thank you for staying a little over, but I don't mind staying if you want to answer a couple more questions.
Oh, we're here to answer questions. So I knew there was one I think got answered that I wanted to talk about. So
yeah, everyone, great questions, by the way. Lot of them.
I know they are great. Oh, if you refinance a property and get cash out, does that trigger a taxable event? If part of the cash is going to pay down your primary residence, does that have tax consequences? Does your spendthrift trust help with those aspects? So if you pull cash out of a property, a lot of people will even ask, if I do an exchange and then do a refinance right away from my replacement property and pull cash out, is that taxable? No, it's not taxable. A loan is never taxable. But what you have to be careful of is once you sell that property, if the loan is much higher than the loan when you acquired the property and you didn't use that money to fix up that particular property, you're going to look at 39.6% in taxes. So be aware.
I put you on spotlight there because that was very, very well said. And so
the trust is the answer for a lot of things. And so we know if you're selling right now, monetize works, 1031 works, but if you do any of those strategies, we still want you to look at the trust for the future.
So I do have here a couple questions. Let's see here. So Claes, did I understand correctly that these methods apply to sale of almost any asset, including a corporation, or just the inventory / goodwill, etc. of a corporation?
It works for the everything but inventory, right? What am I missing, Scott? Inventory.
So inventory and equipment.
Equipment. I went for a blank. So everything but inventory equipment. So if you're selling your business, you want to allocate most of that business cost per sales price to goodwill, because then you can defer the tax on that.
And there is a challenge. You want to move it to goodwill as much as possible so you can reduce the taxes. The buyer wants to put as much into the equipment and inventory to get the depreciation. So it's a little bit of a negotiation battle, but goodwill.
Yep.
Okay, great. I have another question I thought was interesting from Sean. Hi, Sean. Can you comment on the limit for a 453A? I've heard there's an interest charge for anything over $5 million.
Oh, I'm glad you asked that, because that was one I wanted to touch on too. Yes, anything over $5 million per person, $10 million per couple, you end up with this being taxed, right? So the way we get around that is we have an attorney that creates series LLC. So she breaks it down so you don't end up with that tax on there.
I interject quick.
Go ahead, Barry.
The essential point there is that it's a per transaction limitation too. It's not like an aggregate number. That's why the series situation works. And can I just add one thing to a comment Ruth made a little bit ago about the trusts and timing? The trust is an awesome tool. It can do an awful lot of things to help with tax mitigations. It's honestly, short of a Cook Islands Trust, which is all offshore related stuff, it's the best asset protection that you can get. When it comes to tax mitigation, just please, keep in mind that if you try to do something at the last minute and you've got a transfer to a trust, and then the trust is turning around and selling something for a significant gain, you could create an audit situation for yourself. You just need trust solutions require the property to be owned by the trust for a bit of time before you turn around and sell it. Whether that bit of time is 6 months, 12 months, 24 months, 15 years, depends on the circumstances. Isn't every 15 years, but it depends on the circumstances. Depends on where we are in the calendar in some ways, to be honest. But it's difficult to use the trust as a tax mitigation tool at the very last minute. It requires a little bit of advanced planning.
Good point. Thanks for clarifying, Barry. And also, Barry, thank you for answering so many of these questions that have come in. I'd love to share your answers and some of the questions that the attendees have put in. Is it okay if I share this? Okay, great. So another one here, can you go back and put the proceeds from the sale of an investment property into a trust, from Betty?
Yes, you can. As a matter of fact, one of the strategies that does work really well when time gets short is to do the initial deferral of the gain from that sale using an MIS, using a monetized installment sale, and then to transfer the proceeds from the monetized installment sale into the trust and make your subsequent investments through the trust. That's something that we can clearly do at the last minute. Ruth is a glutton for punishment in addition to being a saint. She offered to help me yesterday with people who were driving to a closing to try to get a monetized installment sale in place for them. And it just didn't quite work out on their end. But we can do last minute things using a monetized installment sale. And then we transfer the sale proceeds into the trust where we can do future tax mitigating work much easier, and we can wrap everything inside bulletproof asset protection.
Wow, that is the most last minute I think you could possibly try to attempt something like that. But hey, good on them for trying, right?
Barry called me and said, Ruth, can you do it? I said, I'll drop everything to get it done.
I love
one
it.
more thing, if I can, Alexandra. I don't know where you are time-wise, but
it's up to you.
Okay, so one thing that comes up an awful lot, especially in California, is the idea of using LLCs and corporations and things for asset protection. And there are a couple of, not a couple, there are a bunch, but there are a number of court case decisions and even provisions of the California Corporate Code that work against the idea that owners, whether they're shareholders or they're members of an LLC, that those owners of entities that have fewer than 35 owners can avoid personal liability for claims against the entity or entity liability for claims against the owner by using an LLC. Specifically, you want a piece of trivia the next time you're playing Trivial Pursuit, I guarantee you'll win on this one. California Corporate Code 17703.04 little b, little letter B like boy, specifically makes it explicit in California that members are subject to the common law governing alter ego liability and shall be, it doesn't say can be, it says shall be personally liable under a judgment of a court. And because this trust is technically not an entity, it's technically a contract. And the contract between the grantor that sets the trust up and the trustee that manages the trust says that the trustee is not permitted to distribute income or principal from the trust to anyone who is not a beneficiary of the trust then for the trustee to pay money in settlement of a lawsuit would be a breach of that contract. And California's probate code is very explicit in not permitting that kind of breach to take place. So the reason the asset protection that Scott and Ruth talked about works so well with the trust is because the trust is technically a contract, not an entity.
Thank you
All right.
so much for that detail. I did not know that. That makes a lot of sense. Now I get the background of it. Okay.
There was one question asked and I accidentally hit that I would answer it live, but it says, if I can't afford to pay the 39,000 upfront, what are my options? We actually have some entities out there that will loan funds for the trust. So reach
that's
out to
good.
us.
It's good to know. Scott, I also saw you marked wanting to answer Colette's question live. Do you want to go ahead and answer that?
Yes. Should I transfer to a trust and investment property in New York before putting the property for sale? If you're looking at using the trust as a tax mitigation tool for an upcoming sale, a tax attorney we know has advised that it's best to set up the trust, put the asset into the trust in one tax reporting year, and then sell it in a different tax reporting year if you want to reduce the chance of getting audited. So that doesn't mean it's a legal issue. It's just that it could be more likely to trigger one of those long, painful, expensive audits. So if you're thinking of selling it next year, then this year's a great year to do that. If you're thinking about selling it next month, we can do that, but do you want to increase the chance of an audit? And some people are like, bring it on. It just depends on your personality.
And in that scenario, I would go back to doing the MIS first, if that's at all an option for you, and then transferring the proceeds to the trust, if you can make that work. Then you don't have any audit risks. I don't know if you guys answered Molly's question. I was answering something else. So
I know. That's what I'm trying to, it's a little, you get a little bit trying to answer questions.
and I lost
listen
my
and
place.
get-
So did you answer her question about whether the entire proceeds and the entire transaction has to be an MIS with a shared property?
I did not answer it, so answer it live.
Does the entire transaction have to be an MIS when a shared property is being sold and one person wants to cash out and the rest want 1031? We are already in escrow. There are 4 siblings, one owns 50% and the other 3 each own 16 2/3. So basically your question was, is there a way to do a partial MIS and a partial 1031?
Fractional
That's what the
interest,
question is.
yes.
Right.
So the answer is it depends. You know, if your fractional interest is $50,000, just it depends on the numbers, but the answer is technically yes.
So I like what you said there, Scott, really, I think, and you mentioned it earlier, but it's worth bringing up again that regardless of, what strategy you want to go with, you really have to run the numbers to see which one makes sense, because you might really want the benefits of the MIS, but maybe something else might make sense, especially in a situation like that, where you might, depending on I guess it depends on the price of the property, right? So
Yes.
that's interesting to know, but it's good that it is possible. It's just a matter of running the numbers and seeing if it's logical to do
Yes.
it, right?
We've advised many people just to pay the tax.
Yeah. One of the questions was, can you refresh my memory about the MIS, please? Go to our website, Defer the Gains Tax, or go to our YouTube channel, Defer the Gains Tax. And we have videos on exactly what we presented today. So you can watch it and you can show it to, maybe if you have partners, show it to them and see how it works. Plus, Alexandra, you're going to send this back out to everybody, right? You
Yeah,
said that earlier?
absolutely. And I'll put in the link to your website and your YouTube channel for everybody to review that as well on their own time. Did you want to answer any other questions, or do you want to maybe table this and answer them individually?
I've got till 5 o'clock.
Well, I know I'm trying to go through them. So Scott, this might be a good question for you. Is there an estate value floor before below which you wouldn't recommend the type of trust? I say no, because you need asset protection. It doesn't matter what you own. Somebody can take it away from you. So that one, I say there's no value. It would, anything that you have, just your primary residence is a reason to have the trust.
And
Especially given what risk factors there are liability wise in the rest of the way that you live your life. If you were an OBGYN, the fact that you have a heartbeat means that you're subject to being sued every day. So the asset protection capabilities of the trust are especially important for people in professions that come with a higher likelihood of being sued. If you drive for a living, I mean, it just depends on, if you look at your life and you say, I am more, if you own rental property, for heaven's sakes, especially, and especially in California, your tenants assert rights over things that boggle our mind on the East Coast, back where I am, right? And they can sue you because they don't like the color of the house, the color of the paint that you put on the house, and you destroyed their view of the sunset. So you have to look at the risks that are a part of your life, not necessarily the asset values. As Ruth says all the time, anything you don't want to lose in a lawsuit belongs in that trust.
Yep. So Derek asked a question: what issues do you have with refinancing a property that's in a trust? Some lenders have issues with lending in the trust. You're absolutely right. So if you run into that situation, you simply take the property out of the trust, which you can do, and then go ahead and refinance it and then put it right back in, just as you would a revocable trust that you would currently have for yourself. So no different. Just take it out, refinance, put it back in.
And you can also let us know that you've got an issue like that, and we can connect you to lenders that do make loans to properties in the trust.
And then Jeff asked, 39,000 seems to be a lot of money. Why is it cost so much for the trust? This because of what this trust does. If you're looking at deferring $100,000 or more, or I mean, any amount, I just picked 100,000. In capital gains taxes, 39,000 is very small for everything it does. There's a lot of collaboration in creating this trust. So yes, it is more expensive, but I tell you, that is definitely worth the money. I set up I did the business trust and the personal trust last year, and I'm very happy and relieved that it's in place. And now I don't have to worry about the rest of my life buying and selling properties. The income that I earn is, I mean, I basically went off the numbers. $50,000 last year drops you down to 7,500 to 11,000. That in itself pays for this trust. So I did mine mainly to reduce my income tax bill.
So, and let me jump in on that, because you bring up a good point on the cost. Compared to what? Compared to a living trust, it's crazy expensive, $2,000, $3,000, and you have a living trust. But it provides a lot more compared to other tax strategies. If you have $1 million in assets and you put it into the monetize, that's $67,000 compared to the $39,000 trust. Compared to a charitable trust where $1 million, $100,000 has to go to charity. So if you're comparing it to tax strategies, it's really inexpensive. If you're comparing it to just the avoiding probate, it's really expensive. So what are you comparing it to?
Right. Okay. Another question: is REITs considered like rental property to use on 1031? If the REIT is considered real property and not a partnership interest, it will work for 1031.
Can I tackle one here?
Yep.
Patricia's asking, if a rental property is in the trust and there is a tenant lawsuit, who is the tenant suing? Okay. I'm going to ask the question in a different way. Now, the way that I'm going to ask the question is, if the rental property is in the trust and there's a lawsuit and I lose the lawsuit, do I still have asset protection? And the answer to that is yes. Asset protection is provided by leverage, and California's probate code includes specific language that prevents the trustee of the trust from distributing assets to the plaintiff that has now become your creditor. They're not a beneficiary of your trust. So you're not obligated to pay them. And the courts are constrained by California law from approving a judge or ordering a judgment that would allow that creditor to take against either the assets of the trust or a distribution from the trust.
Let me jump in there, Barry. A lot of this audience is outside of California.
Oh, sorry.
Well, actually, I think we're at about 25% of our members are actually in California, which is
So
Right.
let me
Substantial.
restate it. Those laws that I just described as applying in California apply in almost every state in the country, and they are more explicit in many states than they are in California. So it's the same situation. What provides leverage in a lawsuit is, can you be forced by the court to distribute or pay money to a creditor? And the laws of the individual states prohibit the court from compelling the trustee to pay money to a creditor. What that does is now, if you're you're the client, the person that used to own the property, it's the trust that got set up for you, right? The person that sues you comes to you and says, hey, I have this judgment that was entered against you in that suit you lost, you got to pay me. Your answer to that is, well, first, I don't own anything. This trust owes things. And second, I'm really sorry, but you see, the law says that the trustee cannot pay you money. So look, if you want to talk about a reasonable settlement in your situation, I'd be happy to talk about it. I don't want you showing up on my doorstep every 3 months and reminding me that you've got this judgment, right? But if you're going to be silly about what you expect me to pay for the fact that you lost 2 weeks of work and you broke a leg, then just keep coming back to my house. And I have a client, I'm not making this up at all, I have a client that was in a situation like that in 1993. What is that, almost 30 years ago? And still owes the $100,000 judgment against him, owns a portfolio of about 45, maybe 50 doors worth of rental properties today in a trust, just like the one that Ruth and Scott were describing to you, right? That's asset protection.
All right. So the next question, what are the biggest negatives of the Dynasty Spendthrift Trust to consider and weigh? I don't know any negatives, so I'm going to let you guys answer. Is there a negative?
Well, it's transitioning from how you live life now to living out of the trust. There's a learning curve with
That's
that.
true.
So
My husband's always asking on our trust, because I set up cards, right? The easiest way to do it is I have one credit card for all the trust expenses and one credit card for food, fashion, and fun. So I labeled my husband's credit cards food, fashion, fun, and everything else goes here. So he'll call me, now which one do I put the gas on? Which one do I buy the pizza, right? So, but that's what you got to learn to do. Just know which ones to buy the pizza on and which one you can put the gas on. Then you have the trust checking account, pay that credit card bill, and you're good to go.
So there's a lot of rules you have to apply. So it's getting used to it. The first year you're in a fog, you're figuring it out. Once you get that down, then it becomes easier. But there's tax reporting that has to happen every year. So you have to be able to have everything in place for that, because this is set up for your beneficiaries. So even if you put your primary house in there, you can use it, and income you have can be used to pay off expenses on your primary residence. But really, there's a lease back you do to the trust, and there's just a lot more complications. So we don't want to say there's no issues. It's the changing of how you do your living and how you work out of a trust. Once you get that down after the first year, then it's easy.
Call me. I'll tell you how I do it. So it's pretty simple. Next question, with Biden's proposal, does it make sense to pass to heir now to capture step up advantages? And can you transfer back to yourself and then back again to heirs to step up again? No, 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 no. If you transfer to your heirs while you are alive, there's no such thing as stepped up in bases. You transfer to them now, you are transferring your tax bill when you transfer the property. So do not transfer to your heirs now without, you want to put everything in the trust. So when you pass away, it transfers without all the worries of property tax bill changing. If you're in California, Prop 19 just happened. So you can avoid all of that. If you put everything in now, when you pass away, the trust still owns it. So nothing happened, right? It still owns it. So property taxes are not going to go up. There's no step up in basis. Everything just stays the same.
Can I tackle one?
Yep.
Gail has a question, keeps moving on me.
Okay.
Now, it's a long question.
Okay.
It says, if you have an irrevocable family trust with all the properties already inside of the trust, can you move that trust into a monetized installment sale so that we can sell one of the properties and reinvest it into other properties with the proceeds? First thing we would have to do is get you connected with Scott and Ruth so that we can have a look at the irrevocable trust itself. The instrument will have more answers to that question than anything else. And unless there is a prohibition in the trust, then you wouldn't have a problem with that at all.
Right.
Question goes along, this goes further to say, what about stocks that had huge gains? Can they be moved into the MIS and then sold and reinvested into real estate or any other asset? I'm also actively buying and selling assets with the trust, but using a 1031 is not going to work. And Ruth, before I turn it over to you, I'm just going to say, and what about crypto and gains in crypto, et cetera? Can they be mitigated with a monetized installment sale like the stocks with the huge gains? Go ahead.
Monetized, yes. 1031 crypto, no. But I'm just thinking when he says that you can't do a 1031 on an irrevocable trust, I don't know that to be correct. I would definitely look at doing a 1031 with an irrevocable trust as long as the irrevocable trust sells and the irrevocable trust purchases. I don't see a reason why you can't.
I got the idea that he was referring to the stocks.
Oh, okay. Okay. Got it.
Yeah,
So-
now with the stock, you have two options. If it's publicly traded, you cannot do the monetized. You have to look at other things. If it's privately held stocks, you can do the monetized. So it really depends on what kind of stock you have.
And if you get with Scott or get with me, we can talk. It's beyond the scale of this conversation, but we would have to go through a lot of detail. But there are ways to use the trust in situation with traded securities. In other words, public securities, mutual fund shares, those kinds of things. It's just we have to be careful to cross T's and dot I's, and that would require individual conversation with
And
somebody.
that's
not
with
a
that
generic
really
answer.
smart guy, wherever he is on your screen, with Barry.
Scott can do that too.
Trying to go through and answer some of the questions. So
There was a question that I saw that said somebody's trying to buy a property for their child or with their child. And I thought maybe you guys answered that already.
I did. I did.
Because it went away. All right.
And it says, how do you charge for your services? Our services are free to you. When we do the work with the capital asset dealer and the trust, we get paid by them. So there's no additional cost to you.
Does one put your trust into your living will and trust? So the technical answer to all of that is ultimately, I have a trust client who we are working with to get a separate revocable trust set up because of some particular situations in his family. And we've already put in place a pour over will for him that just redirects anything that gets found after he passes to that revocable trust that we're putting in. Question about a living will. The trust that Ruth and Scott were describing does not take the place of a living will or an advance directive, whatever they're called in your particular state. Those are documents that give someone the authority to speak for you in the event you can't speak for yourself regarding medical care. And the trust that Ruth and Scott were describing to you doesn't address that kind of issue. Let's see, if I buy a property with a mortgage, I can't do it as a trust since the bank likes to see personal income. Well, I was going to say this when Scott was talking a little bit earlier about learning how to live with the trust. If you're bright enough, which just about everybody is, to learn how to live with a corporation or live with an LLC, it's just a different entity. It's just a different thing that you're learning how to live with and getting used to how you do this or that with the trust. If you're somebody that, you've got a business and you've got a nice hobby, in the real world where people really live, most people, maybe once in a while might pay for something that has to do with their hobby, with their business debit card or something like that. And in the scope of thousands and thousands of annual transactions done for that business, is that hobby expense going to get picked up? Well, probably not. Okay. It's not saying that you bend the rules on purpose. It's just saying that you learn that if you don't keep good records in your business and you get audited, you're defenseless, right? No, the IRS is not going to take your word. You got a tax return that shows 10 million of income and you claim $9.5 million worth of expenses, but you got no receipts. You've got a problem in an audit. So you just learn to keep the right kinds of records. And when it comes to buying properties with mortgages and the banks, and personal income and all of that, understand that these trusts, because of the way in which they're used, they get the same kinds of financial statements created for them that individuals do or businesses do. Profit and loss statement, balance statement of income and cash flow, tax returns, etc. So when you go in to apply for a mortgage against a trust-owned property, you're not taking personal income related returns and financial statements. You're taking trust financial statements and trust tax returns. And that's how the loan gets underwritten. And if they ask you for a personal guarantee, you give them the personal guarantee, because if we've all done our job right, virtually everything you own is going to end up inside that trust where it's insulated from the claims of creditors anyway. Give them their personal guarantee and get your property financed.
All right, Barry, there was another one that says, what would happen to the trust if your company went out of business?
If they're asking about your company, like financial tax strategies, that company, our continued existence.
Or the company that creates the trusts.
Right, any of them. The trust instrument, once it's created and signed, once it's executed and has its tax identification number, its continued existence is independent of anything else that goes on anywhere else in the universe, right? It is created. There are no annual filings. For example, if you do live in California, there's nothing to file with the Franchise Tax Board on an annual basis. If you live in Maryland, we call it the State Department of Assessments and Taxation, right? There's no annual report to get filed. The trust needs to be renewed every 20 years. And the documents to complete that renewal are included in the original trust package that you get when you get the trust. You don't need somebody's help. It's just a document for the trustee to execute and keep in the permanent records of the trust to establish that the trust was renewed. Once the trust exists, it exists until it is terminated. And when it is terminated, that is the point in time at which all of the taxes that have been deferred for years through the various strategies would end up having to be paid. And if we do our job right, that is generation after generation after generation from now.
All right.
Is our strategy better than the Delaware strategy?
That's a good
Are
one.
they asking maybe about whether the MIS is better than a Delaware
I'm
strategy?
sure the trust.
Okay, so the trust itself is its own independent taxpayer. It is just as eligible an owner of a of a piece of property that's owned within a Delaware statutory trust as you as an individual could be. If you're using a syndicated property through the Delaware statutory trust, in other words, a private placement offering, then you as an individual would probably have to be an accredited investor. And the rules for accredited investors with regard to these kinds of trusts are a little bit different. The trust either has to have 5 million in assets, or it has to have a co-trustee that's a bank or a financial institution or a registered investment advisor, et cetera. So the trust can invest in offerings that are organized as Delaware statutory trusts. One of the things that's confusing about Delaware statutory trusts is a lot of people have the belief that by Delaware statutory trust, by the use of that term, we're talking about a piece of property that you can invest in and keep your 1031 from failing. A Delaware statutory trust is literally just a form of business organization. If you invest in mutual funds, most of the mutual funds that you would invest in are organized as Delaware statutory trusts to take advantage of some favorable tax laws in the state of Delaware. So when you say, is our strategy better than a Delaware statutory trust? Our strategies include the use of assets and strategies that are implicit in the Delaware statutory trust every day. It's not a question of better than or not. The better question would be, can we take advantage of it? And the answer is yes.
All right, so I see that a lot of these questions are anonymous attendee, and anonymous attendee, you need to talk to Barry and plan on having a good couple hours to get all your questions answered. So reach out to Barry, and he is at go.onehub.com/DS Trust. Reach out to him and you guys can have a great long conversation with him and hold everybody else up on these questions.
Yeah, great questions. And actually, there might be more than one person who is logged in anonymously. So if you were, I'm so sorry because we cannot follow up with you, but I would still love to share, the recording and the answers to all the questions, regardless of who asked them. I think that kind of wraps it up. I feel like we're coming to a stopping point here. And Stan, don't worry about it. We're going to email it to you. Any links, any contact info, phone numbers, recording, anything you guys need, it'll be in the email tomorrow. Expect a long email from me tomorrow. So. Thank you guys so much. All of you did a fantastic job just really breaking it down, and I got a lot of great comments already in the chat. So I hope that you can come back again sometime soon. We're really excited to share this with everyone. So really appreciate it.
Thank you.
Take care, everyone. Bye.
Have a great weekend.
Bye.
Bye-bye.